Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 103 of the DWI Guy podcast. On today's episode, we continue the conversation with DWI Master David Teddy. If you have not listened to episode 102, please go back and listen to that episode first. You're going to kind of be lost in terms of where we are in the conversation today. If you have not listened to that, you're also just going to miss out on an incredible beginning to the conversation, as well as some really important lessons from David Teddy in terms of how he developed his DWI practice and tips and tricks for handling a DWI case. David Teddy is the man that wrote the book when it comes to North Carolina, DWI Trial Notebook. This is the man. This is the guy when it comes to representing somebody charged with driving while impaired in North Carolina. So excited to have David on the podcast. I learned so much during our conversation and hope you enjoy part 2 of DWI Master David Teddy. In terms of kind of how you have built your practice, again, it sounds like kind of that began with educating yourself, both, from the law end of things, as well as from kind of the practical side of things. You start to try a lot of cases, do this repeatedly. That kind of brings in new people, and then they go share. They go share with family and friends. You earn that reputation in the courtroom. Other people that are sitting in the gallery are seeing that. What other ways have you been able to kind of build the incredibly successful DWI practice that you have over the years?
Well, I mean, first and foremost is just not being afraid to try the case. Even in superior court. I mean, if you lose in district and I don't know what the conviction rates are across the state, but the truth of the matter is, I try to convince my district court judges that I'm dealing. Sometimes a district court judge will say, "Well, Mr. Teddy, after he's denied the motion to suppress, I've stipulated to the number coming in." He'll call me up to the bench and say, "Mr. Teddy, that's going to be a really good case. You might have a chance in front of a jury." And I'm going, "Well, Judge, I was just in front of a jury."
Yeah, that's one of the hardest things to hear from a judge. It really is.
So I try to talk to the judges about having 12 little jurors running around in your head, and they all don't think the same way. And so if they all don't think the same way, then maybe the jury should be hung, and that should be a win in district court. A hung jury should be a win in district court. But no, I love my district court judges, and I win some DWI cases, and the district court judges talk. They know who knows how to try a DWI case and who doesn't know how to try a DWI case. And I try to make sure that I'm not a clanging cymbal signifying nothing, that, hey, if I'm trying it, there's an issue here. I'm not just here to take up your time without some basis. I mean, sometimes you'll have a client say, "Well, I want a trial," and the client has no chance, and it's the client's call, it's not your call. But trying cases in district court and establishing a reputation for knowing how to try them, I think it helps you across the bench in district court. And then when you take them up to superior, not being afraid to put a case in front of a jury. And juries are, to me, are much more receptive to arguments about impairment than district court judges are. The jurors aren't running for re-election next year to be on another jury. They don't want to be on another jury next year. They want to do this job and be done with it. And they're just much more receptive to concepts of reasonable doubt. And because I do the same narrative about the government being in charge of this machine that nobody's really ever explained to them. And it is just a witness. I mean, I'd say that intox box is just another witness in the case, and it spit out a 16. Now, you've seen my client. You saw my client drive the car. That witness, that intox box, said he was twice the legal limit. Do you think it was twice the legal limit? So you get to this disconnect theory where the evidence that the government has put out there that the state is wanting you to rely on, they're wanting you to disregard the fact that it was a speed and stop and the officer has admitted that speeding is not a DWIQ. They want you to ignore the fact that he did perfectly fine on the finger dexterity test and he did okay on the walk and turn, just minimize whatever it is was wrong about the standardized field sobriety test. And he just didn't look like a 16. If he didn't look like a 16, then maybe he's not a 16. And when the judge talks to you about credibility of witnesses, because there's a credibility of witnesses instruction, that judge says you can believe all, some, or none of what a witness says. That intox box is a witness.
Yes.
Disregard it.
That's so important to say.
And then now do you think that that person had consumed a sufficient quantity of alcohol or some other impairing substance so as to cause them to lose the normal control of their mental or physical faculties? Do you think that's what this person showed to you on that tape? And if you don't believe that, then the judge is also going to read you the reasonable doubt instruction. And the reasonable doubt instruction says a reasonable doubt is a doubt based on reason or common sense arising out of some or all of the evidence, or the lack or the insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies. Hear me, ladies and gentlemen, fully satisfies or entirely convinces you of the defendant's guilt. And if you're not there, it's okay. If you're shrugging your shoulders, it's okay. Not guilty. Just go back there, mark not guilty on that verdict sheet, and let's go home. And just you do the disconnect theory about, and I do confidence in machines and what happens when we have so much confidence in machines. And I talk about the Hindenburg. That was a ship that should never have come out of the sky. The Titanic was not supposed to sink. The Challenger was not supposed to explode. But when we put confidence in machines, like the state's putting confidence in this intox box and wanting you to make a decision about what's going to happen to the rest of my client's life, sometimes we make mistakes. So y'all looked at it, y'all saw it. If you're not convinced beyond a reasonable doubt, it's okay to mark not guilty on that verdict sheet.
Yeah, no, I think that is such a powerful theory. And I think it's so important to kind of reemphasize why taking a case in front of a jury works. District court is about efficiency. It's you're seeing 100+ cases a year as a judge. If I'm going to look at this disconnect theory every single time, that's going to slow things down, right? The number just sticks. Like basically whatever the number says, I'm going to use that one way or the other. It's easy. It makes it easy to make a decision. The jury doesn't have that problem. That one of the first cases that I took up on appeal was a .09 case. My client had done really well on field sobriety testing. The officer had really done a bad job in field sobriety test. He was on the DWI task force, but had just made a mess of the field sobriety test. And so, his testimony came out very poorly. But when I appealed it and it was a .09, another attorney in town said, what's your, what are you challenging here? You got a .09. What's the issue? And I just said, well, the evidence doesn't seem to show that my client's impaired. I mean, my client did well on everything. And ultimately the jury came back with a not guilty on that. And I think you can stretch that even further. I think the disconnect theory may even work better, almost like the higher the number is, if you've got a client that doesn't show those clues, because again, it's like you just said, you've got somebody that shows twice the legal limit on the machine, but is talking normally, no slurred speech, no difficulty understanding instructions, no, 0 out of 8 on the walk and turn, 0 out of 4 on the one leg stand, something's missing here, guys, and it's not the officer. The officer is here to be, questioned, and he's been able to talk to you. Like you pointed out, this machine witness that is over here, nobody can talk to it, right? Nobody can say, were you having an off day? Were what was going through your brain at the time? None of that, that's just 100%, reliable in terms of the state's position, but there's no, reason to believe in that. So that, I do think that, juries don't have this efficiency problem. It's like, I'm only here maybe once in my life, at the other end of the spectrum, once every 10 years or something. I don't have this efficiency problem, even if I have a lot of other things that are demanding my time. I do want to make the right decision in this particular situation.
Yeah, the disconnect theory doesn't work in district court.
Yeah,
if the number comes in, your client's toast.
Yeah, toast.
I've tried it a couple times. May have had it work once, and I'll even ask the judge. I'll say, "Well, Judge, I'm now at the point where I would be making my argument on disconnect theory. Would you like to hear it?" I don't want to hear it. Let's move on.
Yeah.
So, but it is effective. I've won a 16 on a disconnect theory in front of a jury, and everybody's going, "Oh my Lord, how did that happen?" Well, jurors are human beings, and jurors can sympathize more with the defendant than a judge will, and go, "Lord, that could be me." And you're saying that machine says I'm a 16, and he looks like that. I mean, something's wrong here.
Yeah.
And it's the government's machine is the problem. So anyhow.
Yeah,
It's
it's
fun to win. It's fun to win a 16.
Oh, yeah, that is especially when that's the basis for the win, right? Like, I mean, it's not driving, it's not, some other issue. It's just, again, something on the state's evidence doesn't match up. Or I'm going to start using government. I got to say government. I'm going to have to get in the habit, David, of
government. Government.
You had put something kind of interesting into the notes, because this is something that I don't feel like as a defense bar we talk about very much, but you had kind of put in a question of how to properly charge for a DWI case. So maybe talk a little bit about that, because again, I think that's something that we just don't spend a lot of time talking about.
Yeah. So, well, I think the key to being able to adequately charge for a DWI case is you have to first get the education. You have to be able to talk the talk.
Yes.
If you're gonna, and walk the walk, if you're gonna ask somebody to part with a significant amount of money to have you take a look at their case. And so that's first and foremost. You got to go to standardized field sobriety school. You got to go to DRE school. You got to go see how an intoxilizer machine works. You have to go to some of these national seminars where people come from all over the country to teach DWI law, and you just become a sponge and you just soak up all this knowledge, and then you come back to your community and you unleash all this knowledge that you have pirated from all these people, and you automatically have the credibility in your community as being a lawyer, that if I got this kind of charge hanging over my head, that's the person I'm going to go see. So that's the first part. The second part is actually trying cases, not collecting the fee. You've heard the term bleed them and plead them. You can't collect the fee and then automatically start talking about when we're going to plead you guilty.
Right.
Either. You have to explain to the client that you're going to collect the fee, and you're going to look under every stone for a way out. Now, the reality is, though, a number of the cases that come into my office, after you start looking under the stones, after you start looking at all the affidavits, making sure all the boxes are checked, you've examined the videos, you've examined the intox room video, the CAD reports. You can go through that process and you don't have much to work with. And so you got to tell the client on the front end that it's kind of like paying a doctor to do exploratory surgery. You need the exploratory surgery to see what's going on. You need to do a bunch of tests to see what's going on. And all that costs money because it takes time and technology. So you got to prepare the client on the front end when you're charging the fee that I could charge this fee to you, and there may not be anything here. But when you go see a doctor and you pay the doctor tells you the same thing.
Right.
I'm going to charge you this fee, and you may be sick, you may not be sick.
Right.
But we have to go through a process of finding out. So setting expectations on the fee discussion is important. Making sure that the client doesn't hear, if you pay me X, then you're going to get me out of this DWI, which I have had clients say they have heard me say, which I've never said. Or I've heard them say that other lawyers said, if you pay me X, I'll get you out of this DWI. And that's just not a conversation that leaves my lips.
No. Yeah. I think just quickly to interject on that front, I think this is one reason why, if you're wanting to get into the DWI realm, or you're in that realm, you really do have to love trying cases. I mean, I think that's so important, because, at the end of the day, it's probably easier. I mean, it definitely is easier from a time perspective to just enter a plea. And so that starts to come into, if that's in the brain, if that's in the mindset, you'll find like a way to convince your client to enter a plea, right? Like, you can paint the evidence however you want, just like the officer can paint the evidence however they want. So in terms of having that legitimate, kind of review of the case and looking under every stone, the attorney that is looking there and really like hoping to find something good, like hoping to find a nugget, is going to be the one that longer term wins the game, because they're, the true interest is the client's best interest, right? Like that, where we're trying to find something, and sometimes you don't, like you said, a lot of times you don't, but it is the look legitimate, I think, is a really important factor.
And DWI has become such a political crime that when you do win one, that client walks out of that courtroom and he or she's got a circle of influence of at least 10 people.
Yes.
And those 10 people are going to hear that the unwinnable case.
Yeah. Because they've been told by other people, you got no shot. We're just going to go on and plea. Right.
Yeah. So that builds your reputation. And then that helps you when you're having the conversation with somebody that hey, I heard you got this person out of the DWI. Of course, then you got to set expectations for that client. Say every case is different. All the facts are different. I'm not saying I'm going to win your case, but we're going to do everything we can. And this is the fee that we charge to do everything we can to try to find a way out if we can. So as you try cases and win cases, it becomes easier to charge for cases. If you plead all your people guilty, the old saying is 100% of the people that are plead guilty were found guilty. If all you do is plead them guilty, then you're not going to get a reputation for sometimes pulling people from the abyss of a DWI conviction. So you got to try cases, and you got to try them in district court, and you got to try them in superior court.
Yeah, I love that. You in terms of building that reputation in the community, I think that's the easiest way to do that. I also think that it helps you kind of establish, again, trust with the DA, trust with the judge, in terms of, okay, if this case is going to trial, there's probably something here. Or, from the DA's perspective, sometimes in Buncombe County, you have multiple DAs coming in and out of a particular district courtroom. And so, they know when a case is probably going to go to trial, and when it's not, who's going to try a case and who's not. What are some of the ways that you found it, outside of just being kind of a expert when it comes to DWI defense? What other ways have you found it helpful to kind of build trust with the DAs and with judges?
Well, I don't. Well, first of all, just treating DAs and judges like human beings. I mean, it starts when you walk in the door at the security gate and treating the person that's manning the security gate. Totally. Slowing down. Hello, how are you? How are the kids? Just being a nice person, I mean, goes a long way. Instead of walking in 10 foot tall and bulletproof, Billy Badass lawyer, I know everything. I learned early on that I didn't know much about nothing. And the clerks in the clerk's office knew as much more than I knew. And you get a couple of clerks that take you under your wing and let them know that that they know more than you know. Right. So good relationships with the courthouse crowd, and smiling and engaging them and talking to them and talking to judges in the back hallway about family, and just being a genuine human being goes a long way to building trust throughout the entire courthouse. When you're in the courtroom and you got this audience of people behind you, the vast majority of which have been accused of a crime, that is a future market for your services. And if you're using profanity, if you're picking your nose, scratching your ass, not dressed appropriately, it's how you are perceived by a subset of people that might need your services one day.
Yes.
Try a case really hard, you win, you walk out, you got 4 or 5 people that want your card.
Yeah, that to me is one of the best forms of marketing or branding. Yeah. Going to battle in the courtroom, because you do have an audience, whether it's the court personnel or the people in the gallery. I've had referrals come from court personnel. I've had people stop me on the way out, even after losing a case. I'll have people stop me and say, "Hey, can I get a card from you?" That was And
even officers come into contact with a number of people that they arrest on behalf of the government. If you have eviscerated an officer gratuitously, and you impeached him, but you just didn't let it go, and you made your point, but then you just tried to just drive him into the ground to humiliate him or her. I don't do that. I have a really good relationship with my officers, and I've represented a number of officers that have gotten on the wrong side of the government. And it's because I've treated them. I've tried the cases hard, but at the end of the day, we shake hands, and I realize the officer's got a job. The officer realizes I have a job. And so it takes a while sometimes for the young ones to get there, because they feel like they've been beat up. But sometimes you'll have an older officer that will come over and say, "Look, Dave's just doing his job. He's not a bad guy." So the good relationship that you had with that trooper that's been there for 15 years can sometimes help with these young troopers that come in and feel like that they should win every case, and that if they hadn't arrested him, they wouldn't be guilty. So I try to be friendly with everybody, all the stakeholders in the system, and not beat people up just for the gratuitous. Just in a way that it's just not necessary. So
I totally agree. I think like you said, treating people like human beings it's such an easy thing to forget, I think, for a lot of us, because we're always in such a rush. That's just kind of the society that we live in. Everybody's moving on to the next thing, and anytime you slow down just a little bit at this point, it's very noticeable. It's like it's such a easy way to win. It's just by slowing down a little bit.
And I'll be 59 in May. How old are you, James?
36.
So that's a pretty good spread. The older you get, the more this whole idea of slowing down and this conveyor belt system of justice that we seem to be on, where everybody's trying to see how many cases we can move through the system, especially in a post-COVID world. I think it's the responsibilities of lawyers to slow things down a little bit and not get caught up in this grinding up of people in the justice system, which can happen. It happened before COVID, and I feel like it's really happening now. We're doing 3 weeks of trial terms in Superior Court, followed by an admin week with no weeks off. And if you do any kind of district court practice, you're always on the hook for Superior Court.
Yeah. And, you're in a much worse position on the criminal defense end of things if your client is a number and not a person. You're in a huge disadvantage already, but as soon as you're just a file on either the desk of a judge or a DA and not a human being, your guy or girl is in way more trouble at that point.
Yeah, you got to breathe life into that file. And a good friend of mine, and I've told this story many times, a good friend of mine named Chris Fialco that does a fair amount of federal work. He doesn't do any DWI work, but the concept applies across all cases. But he talks about the kitchen table conversations that he has with his clients, where he actually goes into the home. Now, I don't know how you could possibly, I counted, I've got 133 DWI cases pending right now, so I can't visit 133 kitchens.
Right.
But Chris, in a number of cases, will just walk into the house and sit down at the kitchen table and have a conversation with his client's mom, brother, sister, dad, and just try to see where the client lives and eats. And it puts you in such a better position to be able to articulate to whoever you need to articulate to what your client's all about.
Yes.
And tell that story, because good lawyers are good storytellers.
Yes.
I mean, we're not all Jerry Spences, but if you tell a good story, jurors and sometimes judges will latch on to what you are saying because it's presented in such a different way. And it's clear that you've done your homework and you've done your research and you've done your digging, and you've told something different than, my client is 35. He works at Walmart distribution. He has 3 kids. And that's it.
Right.
If that's all you got to say, then you haven't really gotten to know your client.
No, for sure. Yeah. And that shows over time as well. I think it's not only powerful in terms of that communication piece to judges and to the DAs, but I think it's also a really powerful, if you want to call it like sales tool in terms of the consultation. You know, if you're just trying to get through the questions and basically, all right, here's the fee, boom, like on to the next thing. Again, massive disadvantage in terms of just like a conversation with the client and basically being like, I'm not on the timetable right now. You know, this call can go on as long as it needs to go on. You know, I want to hear about the case. Tell me about your life. Tell me about kind of, you know, the pertinent issues to the case. As soon as you start to let it be known to the client, we're not on a clock. I think that's a massive difference because of that. Again, everybody's so used to this efficiency process and everything in their life.
And if you shift that same paradigm to the medical profession these days has gotten in that conveyor belt.
So much
patient mentality. And once in a while, though, you'll have a physician. I know one who's now retired, but he was completely the opposite. He refused to let the number of widgets he had to cram into that day that the hospital was telling him he needed to do, or his medical group was telling me. He said, no, I'm going to spend as much time here as it takes to find out what's going on with you, because I'm charged with the responsibility of seeing if I can help you.
Yes.
So I don't have a 30-minute slot here that's just for you. If it needs to be an hour, it's going to be an hour. So the medical profession needs to also slow down. The legal profession needs to slow down. The court system needs to slow down. And we have got to get out of this idea that, especially post-COVID, that how many cases can we cram in a session? Because the truth of the matter is we cannot try our way out of a once in a 100-year pandemic. We can't do it.
Right.
We just can't. I think that the answer to the pandemic is not speed, but maybe slowing down and taking a better look at the cases and deciding which ones are really worthy to be tried and which ones are worthy to be dismissed, or which ones are worthy to be taking a second look at in terms of maybe a more reasonable plea offer. So,
yeah. And it's, you know, it's kind of, I appreciate that. I've not really heard that position presented, but I think that that's such a, you know, healthy thing maybe for us in our individual jurisdictions to try to advance that theory to some extent in whatever natural way we can do that. Because certainly in a, you know, county like Buncombe and a lot of other surrounding counties in the immediate aftermath of COVID for 6+ months, you know, a lot of speeding tickets, traffic charges were just getting dismissed, you know, no questions asked. You know, if I get hired on a ticket or something, it was like, let me check to see if this is already gone before I go over and talk to the DA for you. But it's you know, that was obviously part of the mentality, is this is in this particular state not worth trying. And I mean, you know, why should some of that not apply in the context of DWI? You know, you got a person that's got a 0.08 and no priors and, you know, no accident, all these different things. Why shouldn't that kind of same mentality apply, that we just don't have an endless amount of time in the court system, instead of trying to pack it all in or add on emergency judges or, you know, have, you know, these specialized DWI days or whatever the solution might be? Why not take a look at cases and say, hey, here's some cases that, we just don't have a triable issue on. It's a marijuana only case, person was found in the hospital, no opportunity to be doing testing. Why aren't we just kicking that? So
yeah. Except there's more paperwork involved in dismissing a DWI case than there is a murder case because it's a political crime.
Yeah, that's right. I guess it might be easier to try it than to dismiss it. So.
Yeah. More people have to find out why a DWI case was dismissed than have to find out why a murder case was dismissed.
Yeah, that's right. Well, I have just a couple more questions for you, David, in terms of the kind of emphasis on taking cases to superior court. What kind of tips can you talk about in regards to either, I know you had kind of mentioned in our in your notes, either regarding jury instructions or how to articulate reasonable doubt to a jury?
So back when I was a young lawyer, I went to Capital College at the NCAJ, and David Rudolph was in my group. And so David, another lawyer that I have a lot of respect for, very dynamic.
Oh, he's awesome.
Persuasive lawyer. But David's tip, and this was for capital cases, but the same holds true for any case that you're trying, is the first thing that you should do when you open your file is you should take a look at what the jury instruction is on your crime, and copy that jury instruction and put it in your file, because that jury instruction contains the elements that the state has got to prove. And that's the beginning of your case. What are the elements of the crime that the state's going to have a hard time proving? In a DWI case, we have a sort of a bifurcated jury instruction that lets you go with a 0.08 or more objective BAC, or the officer's subjective opinion that a sufficient quantity of an impaired substance has been consumed so as to cause you to lose the normal control of your mental and physical faculties. So those are two different tracks that you need to be thinking about. And so on the one track, be thinking about, okay, what's the evidence that my client had lost the normal control of their mental and physical faculties? And David would also say, just draw a picture, line down the middle of the paper and go good facts, bad facts. On the lost normal control, what are your good facts and what are your bad facts? On the 0.08, what are your good facts and your bad facts? What is it about how they capture that 0.08 that you might be able to keep that number out? And if you're able to keep that number out, then you're just dealing with one prong of the statute. So just looking at the DWI statute, I think is important because it constantly reinforces this idea that there are two ways to prove impairment, and you need to start building your case for why they can't get to beyond a reasonable doubt on either one of those two prongs. And it can set you up for having a disconnect argument between the number and how your client appeared. So that's one thing that I do, is I always like to have the jury instruction. I always like to have the credibility of the witness jury instruction. And I always have the reasonable doubt instruction. And I've gotten to the point, I've tried enough cases, and you've heard me through this podcast, I can give you the reasonable doubt instruction by rote memory. Now, I don't just tell it, though, to the jury. I don't know if can you see me?
Yes.
I was talking about, the reasonable doubt instruction. I can say it because I've got it memorized, but I think it's very important to put it on a board and put it on an easel.
Oh, that's great.
And then read it to the jury, and read it really slow. The defendant has entered a plea of not guilty. The fact that the defendant has been charged is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, he's not required to prove his innocence. The state must prove to you that the defendant is guilty beyond a reasonable doubt. And then the judge is going to define reasonable doubt for you. A reasonable doubt is a doubt based on reason and common sense arising out of some or all of the evidence that's been presented, or the lack or the insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies you or entirely convinces you of the defendant's guilt. I like to focus on the insufficiency of the evidence. If the officer gave 1 out of 3 standardized field sobriety tests, gave none of the non-standardized field sobriety tests, that's something that you get to consider.
Right. Exactly.
They didn't do a complete and thorough investigation of your client. They want you to take this intox box and convict my client. And then I walk over and touch my client, put my hand on my client, humanize my client. But make sure the jury understands that this is the instruction through which all of the evidence has to be filtered through. And then try to break it down further in a simple equation. The state's burden on a criminal case is reasonable doubt. What's reasonable doubt? You got to be fully satisfied or entirely convinced. Now,
that's an awesome graphic. I love that.
If you go back there, I want you to write on the blackboard, fully satisfied or entirely convinced. Write it on the board. And then when you get to a particular issue, y'all sit around the table and have a discussion about whether you are all 100%, all 12 of you, fully satisfied or entirely convinced. And if you're not, then the defendant is not guilty. You got to be unanimous. It's like being trying to decide if you're going to get in a boat that the prosecutor has prepared for you to sail from point A to point B, and you are all passengers on the boat. You're going to examine the boat to determine whether that vessel is seaworthy, and you're going to inspect it, examine it, test it. And if there are holes in the boat, you're not going to get in it. And we've shown you many, many holes in this boat, and you shouldn't get in it. And if you've got a case where the number has come in, then I've sort of done this graph where you go reasonable doubt is fully satisfied or entirely convinced, and then 0.08 or more within a reasonable time, or lost the normal control of mental or physical faculties to an appreciable extent. And if this prong of the statute is arguing with this prong of the statute, then maybe you need to throw this prong of the statute out, because that intox box witness is not making sense, because the guy on that tape doesn't look like he's lost the normal control of his mental and physical faculties.
Right.
I realize we have a 0.08 or more. I get it. But if this number doesn't make sense to you, then just throw it out and go with this. And this probably makes more sense to you. And that's why you need to find my client not guilty. And on a case where you don't have a 0.08 number, because maybe you were able to suppress the result for something happened and then the number doesn't come in, then you're just dealing with the subjective prong. So reasonable doubt, fully satisfied, or entirely convinced. Lost normal control of your mental faculties or your physical faculties, to me, being out of control, lost normal control, that's a big burden for the state to meet. Now, the state will say, well, it just needs to be noticeable. But anyhow, I think charts, jury instructions in front of the jury are always very, very powerful, and being able to articulate reasonable doubt. It rolls off your tongue because you've been doing it so long, you know it. But don't go too fast, go slow, because it might be the first time the jury's heard it, and just let it soak in. And sometimes you basically convince that jury to adopt your argument in the courtroom.
Yeah, I think that the charts are really powerful. We've had a couple of guests on the podcast that have talked about, speaking to a jury, particularly in closing argument, and everybody, and obviously now including you, has kind of had some sort of visual presentation going on to the jury. And for the visual learners, right, some people are more auditory learners, some are more visual. But if you're only doing the auditory, then you're only speaking to some of the people on the jury. If you don't have those visuals, and I think we all learn to some level by visual. Maybe you're more auditory than visual, but I think there's a lot of visual learners that you're not talking to if you don't have some of those charts.
And it sets you apart, because most prosecutors don't use charts in a DWI case.
Right, they don't.
It shows you care about the outcome of the case, and you're creative, and it helps you resonate your argument with the jury.
Well, David, I think, kind of nearing the end of the conversation here, any kind of parting thoughts in terms of practice tips or pointers or just life pointers for particularly young attorneys in the criminal defense arena?
Yeah, just when I speak to lawyers all over the state, I usually get to the point in my presentation. You've heard of TED Talks. I call it Teddy Talk.
Yes.
So my Teddy Talk for the day is life is awfully short. And the guy that I was talking to early on, my friend Bruce Park, who was a great guy and my moot court partner, and blew me away that he could define larceny just like that. He was a magistrate though, so he knew all the elements, but we became good friends and almost opened a practice together in Shelby, and Bruce decided he just couldn't leave Charlotte, so we didn't come together, but we stayed in touch after law school, played a lot of golf together. And old Bruce in 2007 went to go see his friends at the courthouse before he played golf on a Friday before Christmas. And I think Bruce was 50. And he had a heart attack on the golf course at Pine Island and died at a very young age. And I've had a brother-in-law die at 46. My sister died at 50. My cousin, who was my brother, basically my big brother that I never had, died in his 50s of pancreatic cancer. And lost my mom at 62, lost my dad at 69. Just the older you get, the more in touch with your mortality. You're much more in touch with your mortality. And I would just say to young lawyers to go ahead and slow down now. I'm 59, I will be 59, and I've been grinding and probably wish I would have not worked as hard as I have worked. Sometimes it's okay to turn that faucet off with new clients. I know you're trying to make as much money as you can, as fast as you can, but there's no guarantee you're going to be here tomorrow. I've just had a whole lot of death in my life from people that I don't get it. I don't get why they're gone. I will never understand it. And I'm reading a book called 4,000 Weeks right now. I was talking about this book at a dinner that our state bar president was putting on recently over at Carolina Country Club. And I was talking about the book, and it talks about improving your relationship with time. And the title of the book, 4,000 Weeks, has to do with the fact that that's about how many weeks we have to live on this planet. It gets you to about 80. So if you do the math and you think, okay, 4,000 weeks is 80, then you can do some subtraction and decide what week you're in your 4,000 weeks. And so it's okay to take time away from work to do what Stephen Covey says about sharpening your saw, and going to Las Vegas to a National College of DUI Defense seminar is part of sharpening your saw.
Yes.
But so is going to the Grand Tetons or to the Redwood Forest or to the beach and doing nothing connected with work. So sometimes I think the legal profession can kind of grind you up, just like I think the justice system can kind of grind defendants up. Lawyers are not 10 foot tall and bulletproof. We have some of the same problems that our clients have. We've had an assistant DA in Buncombe County overdose. We had a chief district court judge in Greensboro overdose. So we're not immune from the problems that plague many of the clients that we represent. And so I would just say to young lawyers, middle-aged lawyers, old lawyers, first and foremost, take care of yourself and don't get caught up in this conveyor belt mentality of how many cases can we get done this week. Take some time off, buy 4,000 weeks and read the book and improve your relationship with time.
I love that reflection, Dave. I couldn't agree more. Beautiful. I mean, reflection. I think it's so important for us to have that space. And, you know, I'm in the habit, you know, currently of taking pretty like regular breaks. Wasn't necessarily always the case, but I feel like every time I do that, there's new, whether it's, you know, to go learn the law or to just have like a true vacation, you always come back rejuvenated. You know, you always come back in a better, in a, you know, healthier mental space. And, you know, whatever fires that you have waiting for you on the Friday before you go on vacation, they'll be there when you come back. So they're not going anywhere for you. they'll be waiting on you. So it's not, they're never gonna go away completely. So you might as well just get used to setting aside that time to work on yourself and be in a good, healthy space. I love that reflection. It's been a blessing to have you on, David. Thank you so much for agreeing to come on and share your wisdom with the audience.
I've enjoyed it and appreciate all the hard work you do. You certainly have a fine reputation in this part of the state. And I think this kind of thing where you are creating a platform and a portal for lawyers to see, using this technology to see how other lawyers do the work that they do. That's how I've learned, is watching other lawyers.
Yes.
There's nothing wrong with pirating somebody else's ideas. I mean, that's how it works. I mean, there's no reason to reinvent.
No, I'm not a very creative person. I've just watched a lot of great lawyers like you, David. This is, you know, it's you're definitely, I think you were at the first CLE. It was a Masters. I don't remember what it was called. Masters CLE through NCAJ way back when. And yeah, I mean, just soaking it all in. I mean, that's the key, you know, no matter what stage of practice you are in. Maybe you have more of a creative flavor than I do, but I've definitely found that following in the footsteps of people that know what they're doing has worked. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.